SJC-11262, Energy Express, Inc., v. Department of Public Utilities.
Mr. Herwood, good morning.
Good morning. Justice Hines, let me add my congratulations to your outstanding judicial career. It's a pleasure to be here before you this morning.
Thank you, but I can't do anything for you.
Understood? And Chief Justice Gantz, I too, when I walked into the courtroom this morning, said, oh my, I had no idea a natural gas pipeline case could draw such a crowd, but I now understand why.
See, well, you don't need sex and violence to get people here. Okay.
I will not be offering you any sex or violence this
That's
morning.
good.
This is
That's
the
good.
area of...
Now that we've managed to get diverted, let me get back on track. Here, why don't we get right to the core of
Sure.
the concern I have with your argument. Section 94F, enacted in 1953, I gather,
Correct.
when there was no such thing as anything other than a monopoly, that essentially it was only what we call, I guess, the LDC, right? It was you basically, the same entity purchased the natural gas, piped it, and delivered it, and that was all that there existed.
Well, not entirely. Back in 1953, there was a FERC-regulated gas utility that sold the gas to the LDC, and that FERC-regulated utility, those rates were regulated by FERC. FERC has this quirk in which they allow those utilities to pass on these excessive costs while they're under review. The refund comes down in 1953, and the question for this jurisdiction is, do we allow that refund to be passed on by the state-regulated utility? And the legislature said, oh, of course, the refund should be passed on to those ratepayers who paid the regulated state rate where the FERC rate was passed on.
So the Attorney General says you're paying it on behalf of, not on behalf of yourself.
Yeah, that's
So that's not it's not a bad argument, I think, because, you know, you could be somebody's agent, essentially. How do we know who has the obligation ultimately to pay this?
the department is entitled to their own view of the policy and law. They're not entitled to their own facts. They have distorted the factual relationship between the marketers and their
How do we
customers.
decide this? There was no evidentiary hearing, right?
There was no evidence because
What papers do we look at to find out who has the ultimate responsibility to pay?
you look at the rules and the orders of the department, and the department had said, when we unbundled this industry and we said that gas marketers can sell to these sophisticated large energy users in a competitive priced market, they said that the responsibility for paying these upstream costs goes to the marketer. They allocated those costs to the marketer when they said that the marketers must pay. And it follows from simple logic, fairness, and law that if you're going to charge the marketers for that upstream capacity cost, and it later turns out they were overcharged, then they get the refund. Okay. Now, no, we would never say that a business incurs costs on behalf of its customers. That's not the right way to think about the market. We don't need to know what happened in that market because the forces of buyer and seller negotiating competitively came up with a price.
Let me ask you something. Initially, the LDC has to pay for both capacities, correct?
Correct.
They pass it on to your client?
They pass some on to the sales customers and some on to the marketers, correct.
To the marketers, and of course the marketers sell to their customers. Do the marketers also pass along that cost, I assume, to their customers?
They may or may not. This is the competitive market that we have set up.
The part that you don't want to answer.
No, I'm telling you, of course they pass on. When I get incurred taxes, I have to pass some of it on to my clients when businesses, but the point is, that's not for the government to inquire. And they admit they do not regulate that relationship. And to say that sellers incur costs on behalf of buyers is a distortion of economic theory. Now, if you...
We're trying to find out who the customer is
yes.
under the statute.
And the customer under the statute is the ratepayer,
But you-
the
right.
person who pays the regulated rate.
Your client is a middleman.
Yes, but it's the last person who paid the regulated rate. These transportation customers have never, ever, ever been charged a regulated rate for upstream capacity. That wasn't part of the deal. They never paid that, a regulated rate. So why should they get a regulated refund?
When the legislature enacted this, the only customers it could have anticipated were the Tom, Dix, and Harrys who's are purchasing natural gas in their home or their business.
Well, one could take the department's argument and take it to its next logical extreme and say many of those ratepayers are businesses. They passed on those costs. Why didn't the department the office towers around this courthouse, those landlords incur natural gas as a ratepayer, and they pass on those costs to the tenants who are heated during the winter? Why, taking the department's logic, any refund to a landlord under those circumstances really should go to the tenant because they probably passed on those costs to the tenant.
But aren't we trying to ascertain what the legislature intended when it used the phrase to refund to its customers? And I guess my concern is 1953 wasn't the intent of it that you had a power company and you had customers of the power company, and it meant for the benefit to redound to the customers, which would be the businesses and homes which purchased the natural gas from the regulated company.
At the regulated rate, and I would agree with you, that's exactly what they meant, at the regulated rate. You must purchase the utility service at a regulated rate to be a beneficiary under 94. If it makes sense, why would you ever think that someone isn't paying a regulated rate would be protected under 94F?
So what happens to the refund if the marketers get it? Do they then pass on the charges that they've collected to people who have elected to buy gas in this alternative, from this alternative source?
Absolutely. Pursuant, if you accept the efficient market theory of economics, and we all have trouble sometimes with it, but assume in the abstract that we all buy into the efficient market theory, the sellers and buyers are disciplined by the market, and the sellers will have to pass on refunds in order to compete. And if you really accept the efficient market theory, everyone knew there was a FERC refund coming. Everyone knew that there was a large check coming out of Washington that was coming to Bay State. The marketers knew it, their sophisticated buyers knew it. The prices that were charged during this 4-year period when the marketers were overcharged presumably included a discount in the overcharge because they knew the refund was coming. And
So why isn't that a function of competition, the market? I mean, the marketers get in there, they decide that they want to offer gas to consumers, I'll say, because that's an easier term. Why isn't that their problem if they end up?
I agree it is a problem, but when the government says to the seller, we're going to impose a burden on you. You have to help pay for this upstream capacity because we have a government interest in making sure the pipeline is big enough to get all that gas from Pennsylvania to the Commonwealth on the coldest days of the winter, and you're going to pay. The government can't switch horses in midstream and say, when the refund comes down because you were overcharged, we now switch and say, oh no, the buyer gets it, the consumer gets it. They could have said in the beginning that the consumer is going to pay for that upstream capacity, and Bay State would have charged a regulated rate to the consumer and said, you pay for the upstream capacity. Then when the refund comes and the $4 million that is allocated to the market comes, they would have been entitled to the $4 million. But the government can't switch in the middle. They can't charge the seller, overcharge the seller, and then turn around and give the refund to the consumer. That's an abuse of discretion, and it violates Section 94F, which clearly says it's a refund. A refund, under the simple definition, is to the ratepayer who paid the regulated rate. We don't go behind the ratepayer to see whether there's some equity or fairness or some that maybe there's somebody back there who may have incurred some of the costs. If the Department of Revenue said to a business, your income tax revenue refund is on its way, there's just one problem. We've decided to give your tax refund to your customers because we suspect you probably passed some of those taxes on when you were overpaid your taxes. We'd say, no, you don't give the tax refund to the customers. You give it to the person who overpaid the taxes. The same thing applies in rate regulation. The party who overpays gets the refund. And it was the department's decision in 1999 to charge the marketers with the cost of this upstream capacity. And they put into the rate that the marketers will pay the FERC rate with the refund.
So is it, you're saying it's like the one who actually pays, the one who actually tenders?
The
Payment
who
actually
actually
tenders?
paid the rate, actually wrote the check.
Actually wrote the check?
Yes,
right.
and the marketers wrote the check.
So
They-
whoever writes the check gets the refund?
Whoever writes the check for the rate, for the regulated rate. That's the key here. It has to be for the regulated rate. There was no regulation of rates between the marketer and the consumer. We said that's off in the competitive market, where the government doesn't know what those prices are, nor should they. We assume that the efficient market took care of that pricing.
When it was unbundled, you said that the rate is paid with the FERC refund as well?
When the governments, when the DPU said to the marketers, you will pay for this upstream capacity, and you will pay no more and no less than the FERC rate, because Bay State pays the FERC rate, and it's a straight pass-through. They also said the FERC rate comes with a refund.
Where is that? Where do I find that?
Well, it's in their case, in the decision. If you look at Appendix 138, you will see the department acknowledges this. And here's one of the interesting things of this case. Bay State came in and said the entire $30 million should go to their other customers, the individuals and the small commercial customers. That's the equitable way to do it. Just give the $30 million. And the department said, no, 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 you can't do that. They didn't pay that. You give them the $26 million that they paid. The $4 million should be returned to the people who paid it. But then the department ignored its own logic and said, we're going to give it to the consumers, not to the marketers who paid the regulated rate. There's an inconsistency in their order. And what they said was, if we had given the $4 million to the sales customers, those residential and small commercial customers who buy their gas from Bay State, that would have ended up overcharging the marketers and their customers because they wouldn't have the refund, which was an integral part of the deal. It was the rate. The refund goes with the rate. They're married, they're locked. And the department in this case unlocked them and said, seller, you pay the rate, buyer, you get the refund. It's a little bit heads I win, tails you lose. And it's an abuse of discretion. It is inconsistent with Section 94F, which clearly uses the word refund, which by any normal definition means to give back, to repay to the party who made the original payment. You can't deregulate this competitive market and then come in and put your thumb on the scale in favor of the consumer just because you think that maybe the seller gained some advantage in prior negotiations and somehow got to keep the refund and not pass it on. If you believe in the market, as this department did in 1999, you have to stay out of it and continue to believe in the market. Now, if they wanted prospectively to say, we made a mistake, we want to charge the rates to the customers going forward, that would be fine. That's within their prerogative. They could have easily said either the seller or the buyer. But you can't start by saying, seller, we're going to overcharge you, refund for the overcharge goes to the buyer. It is inherently unfair.
Statute would have to be amended to make that clear. Your position is, in order for that position to take place, the statute would have to be amended to reflect unbundling.
Yeah, I think that's right. I still think it would be incredibly unfair to say to the seller, you're going to be taxed for these burdens, and any refunds on those go to the buyer. It just doesn't make any economic or fairness sense. But sure, I guess there's nothing unconstitutional if the legislature thought that was And then you would presumably, in the negotiations, the seller and buyer would say, well, the legislature has burdened us with the overpayments and given you the refunds, so we have to negotiate a price that reflects that allocation of risk. But certainly there was nothing when we sat down and negotiated, and remember, these are fixed price contracts that we typically negotiate. These are large consumers, many of them have operations in multiple states, and we're negotiating a single price for them. The question of overcharges and refunds, we assume, was for the seller. It was one of many factors that went into the price. We'll never know in each case who won those negotiations and whether the seller got a slightly better price or the buyer got a slightly better price, and how the refund and overcharges might have factored into it.
You know, I can't help but think that maybe I misread the briefs, but I'm pretty sure that the Attorney General's position is that it is not your client that has the ultimate obligation to pay.
Thank you for raising that. That's a very important point. And the Attorney General makes a big point at what we in the rate regulation business call cost allocation and cost causation. We spend hours and hours. And their point is that the person who had the cost causation was the consumer. The problem with their argument is, back in 1999, the department allocated these costs to the marketer. They made that decision on cost allocation and cost causation in 1999. They said, consumer, marketer, we can go either way. Let's put it on the marketer. This one belongs on the marketer. So they made that cost allocation, and the Attorney General cannot question that now today. That is the law, and they accept that.
And we have a reference in the record to that decision?
Yes, it is in the appendix that in footnote 9 of that 1999 order, the DPU ordered marketers to purchase capacity at the FERC rate.
Okay.
Like, let me just make sure I understand certain basics. 1953, if I were to be buying, I was not yet born for the record, but if I were born, and if I were buying natural gas, I'd be buying it from, I would have one choice, correct?
Correct.
And then the rate that would be paid by me would be purely a regulated rate, that I'd be paying for the pipeline cost, because that would be a fixed, that would be a regulated rate as part of my overall charge?
It would be bundled into your state-regulated rate. You would be buying from Bay State or Boston Gas or whoever your local gas utility was. Included in that bundled rate would be the amount that they were paying in 1953 to the upstream gas supplier, or whoever owned the gas field. And that rate would have been set by FERC, subject to refund.
But DPU or its predecessor would be the one setting the rate.
Correct.
And in calculating that rate, DPU would say, okay, we're going to determine what's a reasonable rate, and we're going to look to the overall cost of natural gas, and we're going to look to what the FERC rate is to transport that natural gas, and we're going to look to what the cost is to deliver that natural gas to the consumer, and we're going to put all these three together and set a regulated rate.
Correct.
Okay. Then 1999 comes, and they say we want to get competition in the industry. DPU is still setting the rate for Bay State, correct?
And they're still setting the rate for all customers for that last segment of the delivery, which is Bay State's local operations.
Okay. So now we say we're going to be marketers. You can purchase natural gas wherever you want to,
Right?
but you still have to pay the same FERC rate to get it delivered. That's your cost.
Right. And in fact,
Has to
we
bear
not
that
only
cost.
give you the option, we mandate, because we want that upstream capacity, those pipelines. So you must.
You must do it, and you must
From the
pay.
volume of business that you have a responsibility to buy at FERC rates or at department rates from Bay State the amount of capacity, upstream pipeline
Okay, so
capacity.
your costs include the cost in the fair market of purchasing natural gas, the cost of transmitting that natural gas via the pipeline, which is FERC determined. That's for you a fixed cost.
Right?
And then the cost of delivering to the consumer, which is also a fixed cost because that's a regulated rate.
Right. And the last piece comes from Bay State and their Bay State bill. The
And they say
marketer
this
pays-
costs
yes.
X dollars per customer, and now that's your costs. But you are allowed then to go to the consumer and say, I'm going to set my own price, DPU is not setting the price.
Correct. And I will
Okay.
rebundle all of that into a market price.
Okay, now, refund comes. If I'm still with Bay State as a customer in my home,
Yep,
the rebate will come to me in some fashion, correct?
correct. That 26 million went to the sales customers, the residential and small commercial, correct.
And they say you have to pay that, you have to give that back to each of the customers by some calculation.
Correct.
But if I'm a customer of Energy Express, you say, no, I don't get that, Energy Express gets it.
Correct, because Energy Express paid it.
Okay, but it sounds as if I'm with Bay State, I paid a rate set by DPU.
But the DPU passed on the FERC, and this is what Section 94F said, is we don't have refunds in the Commonwealth. That's not a normal practice of utility rate regulation in the Commonwealth. So the legislature very wisely said, wait a minute, when FERC passes on a cost subject to refund, and you pass on the FERC cost in those rates subject to refund, the refund works, and we are going to make sure as the legislature of the Commonwealth that you have the authority to make those refunds. When the refund comes from Washington, we don't want there any question that it sits in the bank account of the utility. It gets passed on as a refund to the state-regulated customers.
Okay, but it was Bay State who paid that. Bay State paid.
Yeah, Bay
FERC
State
rate.
is made whole. They paid the $30 million overcharge, and they got a check from this case that was called PNGTS was the name of the pipeline. They got a nice check for $30 million.
But they can't keep it except
can't-
for the administrative cost of paying it back to its
Exactly.
customers.
So the department had to sort out the 30 million, and there's no problem with the 26 million. It went to the correct people, the individual, small commercial. The problem is,
I guess my issue is, why, from the point of view of the legislature, again, 1953, they may not have anticipated all of this, but why would they want us to interpret the legislation to say, if I'm a Bay State customer, I get to keep it even though Bay State paid it, but if I am a customer of Energy Express, I don't get it, Energy Express gets to keep it because Energy Express paid it? Why would they have wanted us to interpret the word customer that way?
I think it makes perfect sense if you think of the concept of rate regulation, which is that all we're doing is regulating rates. Once the marketer goes into the market, it's no longer a regulated rate. For example, back in 1953, there were businesses who got those refunds. They passed on the original overcharges to their customers. If I'm a widget in the widget business, I sold my widgets, and the price of the widget may well have included the overcharge. No one would have suggested, the legislature in 1953 say to the department, don't give it to the widget seller. They probably get the names and addresses of the widget buyers and send the refund to them. That's the equitable, fair thing to do. The legislature was looking just at this with blinders, this regulated, we have ratepayers and utilities and ratepayers, and we want to get that right. What happens on behind the ratepayer? What the ratepayer does with the overcharges, the refunds, is up to the competitive market.
If you want to distill it down, you're saying then you to your customer is not a regulated rate.
That is correct. There's
If
no
you want to
argument.
just get the argument, that's what you're saying.
Thank you. That you've said it much more eloquently than that is the core of the case. And to go into that competitive market and put your thumb on the scale and give the refund to the buyer after you've charged the seller the overpayment is inherently unfair and, in my view, a violation of law.
Well, one last question. So when you paid the inflated rate, did you charge the people who bought gas from you based on that rate?
We can assume that some of those costs found their way into the
Okay.
price. I'm not going to
So-
argue
so-
and pretend that we're so
Those
saintly.
people who buy from you are at a disadvantage if they don't get part of the refund back. I mean, they paid the same as the people who bought from Bay State, right?
I don't agree that they're at a disadvantage. These are large, sophisticated buyers. They went into the market, they negotiated in the market and thought they could do better than buying it at a regulated rate from Bay State. And if you accept the efficient market theory, Both the buyer and seller knew there was a check coming from Washington. They didn't know the exact amount, but all of us in the rate world know these pipelines go in and they ask for the moon and they start charging the moon, and everyone knows once the FERC staff has done its analysis, refunds are coming. How much? How much of it was an overcharge? So we all knew a refund was coming. If you accept the efficient economic theory, those sellers and buyers, when they sat down across the negotiating table, and they weren't agents for each other or acting on behalf of each other, they were tough negotiators. They knew that refund was coming, and in theory, the price allocated the likelihood of that refund. And if the buyer was saying, you're about to get a $100,000 refund from Bay State, I want a part of that today reflected in the price. The seller would have had to say, if the seller said no, they would have gone to another marketer and found another marketer who would have said yes.
Okay, thank you.
Thank you very much.
Mr. Hanson, good morning.
Good morning, may it please the court. Assistant Attorney General Kirk Hansen on behalf of the Department of Public Utilities. I'd like to start with, I think, some of the questions that Chief Justice Gantz and Justice Gaziano brought up about what did the legislature intend in 1953, because I do think that's where this case has to start. It's the department has the authority to order Bay State to return the refund to Bay State's customers. And so the question is, what did customers mean in 94F, and specifically in 1953 when this was adopted? So I think Your Honors noted in 1953, there was only one type of customer to an LDC like Bay State. It was the end consumer at retail who's buying the gas, the capacity, the distribution service to use at their home, at their business. That is what was being considered. There's been no amendment to 94F since 1953. It's never been touched. That was the intent then. It still is the intent within the statute. Specifically here, I would say, I want to correct at least one point. I don't believe that Energy Express is a customer of Bay State. They make it sound as though they are purchasing or acquiring this capacity, but the capacity is only being assigned to them on behalf of transportation customers that have chosen to go to them. The way that the mandatory capacity assignment works, the department back in 1998, 1999, in the unbundling order decided there wasn't a fully competitive market for pipeline capacity, so they still required LDCs to acquire sufficient pipeline capacity for all of their customers, those that would choose to remain and those that would choose to migrate. If those wanted to go buy natural gas from a marketer, their pro rata share of that capacity follows with them, and it follows with them at the FERC cost. It is assigned to the marketer to help for the managing purposes to make sure that the natural gas gets through that pipeline to that customer. But under the tariff, if that customer chooses to then go to a different marketer, if that customer chooses to return to Bay State and get all service from them, that pipeline capacity follows them wherever it goes.
Okay, but let's, if we can follow the money a little bit here. Okay, so in a world in which 100% of people have Bay State, I guess, is paying the pipeline company a FERC rate.
Yes, they've entered into a multi-year term contract at a FERC set
Okay,
rate.
but someone's writing the check, and
Yes.
that's Bay State.
Yes.
Okay, then let's assume Energy Express comes into the business because now they can, and 1/4 of Bay State customers migrate to them. So now they have 25% of the market. They've got to pay 25% of those costs.
Because those customers come with 25% of that pipeline capacity.
Who's writing that check, and who's that check made payable to?
The check for, the way that the system of it works is the check that is being paid for that 25% of the pipeline capacity in the first instance would be written by Energy Express, the marketer, but it is written to PNGTS, the actual pipeline company. The way the process works is the capacity is assigned. The contract is still in Bay State's name, but then because the money is paid to the pipeline, a credit shows up on the bill for what has been paid by the assignee who is now managing
So
that.
they are essentially responsible now to pay 25% of the pipeline cost to the pipeline supplier.
Yes,
So they're writing that check.
yes.
Now, they've written, but all of you are paying at some point the same rate. So I don't know, what is the rate measured by, cubic feet or?
I think that the term is, might be therms At least that might be the natural gas.
Therms-
But then
therm-
then
let's
for...
keep therms. I like therms.
We'll just use
It's
that.
like
That may be for
widgets.
actual natural
Good.
gas, but how much the
Okay,
capacity of
so
the
you're
pipe?
paying, so let's assume the rate is $5 per therm. And they say you get a rebate, so it should be only $4 per therm. You get $1 per therm back for all the 75% that Bay State paid, correct?
Well, technically, the entire, all for that and the 25%, because it's still, the contract is in Bay State's name, so all of it goes to Bay State.
Okay, so you get it all, but then you now have to allocate the 25% to them.
Whereas I should say, the department will decide if there should be a refund, and if so,
Okay,
to
so
who.
that's, I guess, the core issue is that,
There's no requirement to return the refund unless the department pursuant to Section 94F has decided to order Bay State to return the refund.
okay. Now, I guess my concern, I've got issues with both of the arguments here, but the concern I have with your argument is they've paid, in my example, $5 per therm. Should be $4 per therm. If they don't get the money, they're still paying $5 per therm, while Bay State's only paying $4 per therm. And how do you deal with the fact that without giving them the rebate, they are now paying more than Bay State is because they're not getting the rebate?
I think it goes back to the nature of the assignment. When these customers are going to Energy Express and saying that they want to buy natural gas from them, they already have the capacity that's been assigned to them at that $5 per therm rate. If Energy Express is going to say, okay, we will sell you natural gas and we're going to offer you any rate other than $5 per therm for the pipeline capacity, they're choosing to assume responsibility for a cost that is already attributable to and following the customer. That is the private negotiation in the contract of choosing a
Could you
price.
say
And
that
if-
again? I'm really confused. What did you just say?
So when transportation customers choose to migrate to buy natural gas commodity from Energy Express, because Bay State was required to enter into this long-term contract, they've already acquired pipeline capacity to serve the needs of that customer. So when they come, in the way that this works in the assignment, they come to Energy Express, they're coming with their pro rata share of capacity attached to them at that price of $5 per therm per unit. So that's being brought to the table. And if in the negotiated price, either Energy Express is going to agree to take that and charge them $5, pay it directly, but it's going to go straight through. If they don't choose to do that, if they're saying, you come, you bring this over, you bring the capacity with you, yes, we have to pay directly to the pipeline company, but we're not going to pass that full cost on from 5 to 4. That's a choice in that private negotiation. I think
Doesn't that prove too much? In other words, that then it's not the regulated rate? Doesn't that argument prove too much?
Well, I think it goes back to the point of who is responsible. The ultimate responsibility, department go back to, lies with the customer in the sense that that capacity and the cost of that capacity follows that customer wherever they go.
What about the 1999 DPU decision to allocate the obligation to pay to the marketers?
Well, what that decision said, and if you read, it's a lengthy decision, but where they were talking about the allocation, it was because they needed to make sure that transportation customers bore their pro rata share of the cost. That language is throughout that decision. I know it is in the record appendix as a single-spaced decision. I reproduced the signed version from the department in the appendix, or the addendum to the red brief. You can find it there, DTE 98-32B, I believe is the...
Let me ask something. Is there an issue of whether or not the end customer of the plaintiff pays a regulated rate? They don't, right?
No. With regards to...
So how do they get a refund if they didn't pay a regulated rate?
I think that just goes back to, it's going to be, I think, the same the mantra, but the capacity and the associated cost is attributable to and attached to that customer. If there's a private negotiation for a different rate between the marketer and the transportation customer, that is beyond DPU's purview. And if they're going to choose to address something about who should get a refund in the event that a refund comes, that should be determined by the terms of that contract. In this case,
So you're saying that the capacity transaction between Bay State, who's responsible in the first instance for buying capacity, and the marketer is attributable to the customer?
basically, in 1998, when the department was trying to move towards a fully competitive market for both the natural gas commodity and the pipeline capacity, they realized that there weren't necessary market conditions to actually have a fully competitive market for pipeline capacity. There's just not enough capacity coming into Massachusetts.
That's why Bay State has to pay everything.
And that's why they require Bay State to still enter into these lengthy contracts at FERC rates to ensure that there is enough capacity for all these customers.
Right.
And
Now you sell to the marketer.
Well, if a customer chooses to buy from a marketer,
Right.
that customer brings with it its share of responsibility for those costs. Again, it's not being directly sold because, to be clear, Energy Express does not have the right to then, once that's been assigned to them, it can't just then be resold into another state or used to service a customer in a different state, because if the transportation customer were to return to Bay State or go to a different marketer, that same share of capacity has to follow them.
So you get 26 million, you get $30 million back. 26 million is yours because that's your range of customers. That's your percentage. You can't keep it though. Bay State, there's no doubt that you can't keep it. Bay State can't keep it, not you. Bay State can't keep it.
Bay State, yeah, once again, because the department has reviewed it and issued the order saying, return it to the customers, which is consistent with the purpose of, I think, 94F. And as was said back in the 1940s, the Natural Gas Act, the goal is to protect the ultimate consumer at retail. So that's why the department has said to Bay State, you must return the full 30 million to customers. 26 million goes to the sales customers that are still getting service directly from Bay State.
Okay, and how is that done? How is it returned to them?
So bills that customers would receive, there's going to be two portions on the bill. There's basically a charge for what's called like supply service. That's the commodity and transportation charges for the pipeline. It's done by a gas adjustment factor. And I think that there is a adjustment within that to pass on the refund prospectively to the existing customers.
And does that say that when DPU is setting the rate, it is setting a rate for the commodity as well as a separate rate for the pipeline cost and is adding the two up as the regulated price?
I'm not as well versed in the full way of how that works, but I believe that is correct, Your Honor, that gas adjustment factor is balancing all of those costs to set a regulated rate for the commodity, for the transportation cost, and setting the rate for all customers who are still receiving bundled service from LDCs.
Now, all of Energy Express's customers are also Bay State customers to the extent that
For purposes of that distribution service from the city gate to the end.
they're
home
still
or business.
responsible for the distribution for everybody.
Right, and so customers that migrate to buying natural gas from Energy Express, they may still choose to get a single bill from Bay State, where that supply service charge is a number that's being negotiated with the marketer, and that's going to show up there, but that the separate section at the bottom is second part is the distribution service charge that's set by the department for Bay State.
And Bay State will bill Energy Express for that, effectively. It's part of their cost structure.
Well, the choice is either a customer receives two separate bills, one from Energy Express and one from Bay State, or they choose to get a single bill from Bay State. I would kind of analogize it to if we all get notices saying, do you want to buy your electricity from a solar farm as opposed to directly from National Grid? You still get one bill from National Grid. It's just being done on an administrative level. So the bill is going directly to the customer. Bay State is sending the bill for the distribution service to the costs to the customer, not to, I don't believe, to Energy Express.
In the absence of further questions.
We'll rest on our brief and ask that you affirm the department's decision.